Good morning, students. Today we are going to discuss about Article 20. Article 20 deals with protection in respect of conviction for offences. Article 20 consists of three clauses. Article 20 clause 1 deals about ex-post-facto laws. Article 20 clause 2 deals about double J bad A. Article 20 clause 3 deals about self-incrimination. Article 20 clause 1 deals about ex-post-facto laws. Ex-post-facto laws means imposes penalties retroactively. For instance, A committed an offence in the year of 1954. At the time of commission of that offence, it's not an unlawful activity. But later in the year of 1955, the new enactment came into existence which made that offence as a punishable one. Now the question arises whether the new enactment which came into existence in the year of 1954 can be applicable to the offence took place in the year of 1954. So the new law came into existence in the year of 1955. In the 1954, the offence committed. Whether this new law can be implemented on the offences took place before the enactment of the law. Article 20 subclause 1 prohibits such kind of practices. It provides safeguards to a person. That means the criminal law should not be implemented retrospectively. Here, for further classification or for further explanation, I have divided into two parts. First one, no person shall be convicted for an offence except violating the law in force. So here the person can be punished only for the offence which was unlawful at the time of the commission of the offence. So that particular law should punish a person for unlawful activities. That law should be in force. Then only the punishment can be given to the arrested person. Next, second clause, that means second part of the Article 20 clause 1 immunizes a person from a greater penalty. The court should not enhance the penalties which was increased later after the commission of an offence. For instance, A committed an offence in the year of 2010. At the time of the commission of an offence, the 6 months punishment was imposed by law. But later, in the year of 2012, the imprisonment has been increased from 6 months to 2 years. Now, the court is not allowed to apply the new law which came into force in the year of 2012 for the offence took place in the year of 2010. So it immunizes a person from a greater penalty. So the law or the court can give punishment only based upon the law in force. And one more thing, this Article 20 Clause 1 applicable only to the criminal offences, not for the civil liabilities. In the case of Varinder Singh versus State of Punjab, in this case what happened was the Punjab government made an amendment in the year of 2011 in Prisons Act 1894. In that act, the Punjab government inserted a new section 52A. That new section made the possession of mobile phones by the prisoner as an offence. Not only possession, if any person supplies the mobile phone for the prisoners, he is also punished under this new Amendment Act. This act came into existence in the year of 2011. But in present case, the FIR was lodged in the year of 2009. The offence took place in the year of 2009, but the FIR was lodged in the year of 2011 based upon the new amendment. The Supreme Court held that the retrospective effect can be given to the present Punjab Amendment Act 2011 because the offence took place in the year of 2009. As I said earlier, in Article 20 Clause 1, there must be law in force. So that particular law should be in the force at the time of the commission of the offence. Then only the punishment can be given to the person who committed an offence. But in this scenario, the Supreme Court held that Section 52A can't be applied for the offence took place in the year of 2009. The case is Satwant Singh versus State of Punjab. In this case, under Section 420 of IPC, the minimum fine was not prescribed. Later in the year of 1943, the Punjab government came with an ordinance. In that they mentioned minimum fine for the offence takes place under Section 420 of IPC. The Constitution Bench held that this Article 20 Clause 1 not infringed by the trial because the offence took place before the enactment of the ordinance. That means before the ordinance came into existence, the offence took place. As I said earlier, the criminal law can't be applied retrospectively. So similarly, in this case also, the court clearly stated that minimum amount inflicted was not greater than what could be inflicted on a person under the law in force at the time he committed the offence. So at any cost, the court is not allowed to enhance the punishment based upon the new law. Next, we move on to Rattan versus State of Punjab. In this case, a 16-year-old boy was convicted and 6 months imprisonment was given to him. Apart from imprisonment, the court imposed fine on 31st May 1962. Then they moved to Sessions Court, later to the High Court. Finally, on September 27, 1962, the High Court dismissed the petition. In meanwhile, on 1st September 1962, the Probation of Offenders Act came into existence. But the plea was not taken before the court based upon the new enactment. Then they moved to the Supreme Court. In Supreme Court, they argued that the benefit of the act should be applied to the boy who was convicted for 6 months. Under Probation of Offenders Act, the court has a power to release a person for a minor offences. Based upon this act, they pleaded to release a convicted person because the boy committed a minor offense. That's why the court gave only 6 months imprisonment. But this was objected by the government by stating that it's not possible to implement the criminal law retrospectively, and therefore the plea of the boy should be rejected. This was the argument raised by the state government. After taking into consideration, the Supreme Court held that the beneficent construction can be applied to the convicted person retrospectively. Earlier we studied that the greater punishment should not be imposed for a person. But in this case, if there is any reduction in the punishment, it can be applied. So in this case, the offense took place in the year of 1962, 31st May, at the time of the judgment given by the court on 31st May 1962. This act was not in force. This act came into existence only on 1st September 1962. But the offense took place before that. In these circumstances, as we discussed earlier, the criminal law is not possible to bring as a retrospective effect. But with respect to reduction of the punishment, the court applied beneficent construction. In beneficent construction, the leniency can be shown to the person who committed a minor offense. So with respect to reduction of the punishment, the court is allowed to apply the law. But same thing cannot be applied when there is a enhancement of the punishment. For example, A committed an offense in the year of 2009. Later in the year of 2010, the imprisonment has been increased from 6 months to 1 year for an offense. But the new law can't be applied to the person who committed an offense in the year of 2010. But with respect to reduction of the punishment, it can be applied. So that is the difference between both. With respect to enhancement of the punishment, it's not possible to give retrospective effect. But with respect to reduction of the punishment, the retrospective effect can be given to the criminal laws. So other relevant case laws are Sarla Madgal versus Union of India and Lily Thomas versus Union of India. In law, we have some exceptions. Similarly, for Article 20 Clause 1 also, we have some exceptions. This Article 20 Clause 1 does not apply to preventive detention laws, acts done before the enactment of the relevant law. As I said earlier, that law should be in force at the time of the commission of the offense. Clear? Next, demanding security from press law under a press law. Demanding security from a press under a press law. Next, finally, civil liability. In these four circumstances, Article 20 Clause 1 will not apply. Singh Manufacturing Company versus Union of India. In this case, what happened was, Industrial Dispute Amendment Act came into existence in the year of 1957. But before the Act came into existence, few undertakings were closed by the employers. Now, this new amendment, which came into force in the year of 1957, the retrospective effect was given to the new enactment. And they stated that since November 1956, the undertakings which were closed should give compensation to the workmen. Listen carefully. In this case, the Amendment Act came into existence in the year of 1957. But the retrospective effect was given to that act, and they stated that this act will apply for the earlier closure of the undertakings since November 1956. So they gave a retrospective effect to the act. The court held that this particular act as a valid one because it imposes a civil liability on an employer. So these are all the exceptions and various discussions on the Article 20 Clause 1. Thank you.